do it formally, this is Andrew Alder-LaRue. I always call him Andrew Vincent, but
well, I do use my middle name when I go to court. So,
and who's an attorney and has given us lots of information about HIV and the law in the past, and we're interested in the new updates.
Well, good evening, guys and ladies. If there's any, for the audience in the room now or whoever may be joining us, yeah, this is HIV and the Law, Spring 2022. Only this time, I'm actually not going to talk about HIV at all. We're going to have a 101 lecture in constitutional law. Every time I give one of these talks, we always talk a little about constitutional principles, because many of the rights that we enjoy as gay people and many of the burdens and benefits that we share as those who are HIV positive in the HIV community, we are very much affected on a daily basis by constitutional theory and constitutional practice. You all are not lawyers. I don't expect you to come at this from the perspective of a lawyer, but I think it's extremely important, particularly now, that we understand some of the larger principles of constitutional law. And I'm going to illustrate those principles by focusing basically on three areas that I think are worthy of inquiry and review. And I think in doing so, these three areas illustrate how powerful the Constitution is when it comes time to creating laws or creating rights, and how tenuous our grasp is on the legal gains that I think we've made over the last 3 or 4 or 5 decades. And I'm quite serious about that. The Supreme Court, of course, is the governing factor in all of this. And the composition of the court is always important. For those of you who are around my age, I mean, I was a kid when the Civil Rights Act and the Voting Rights Act passed Congress. I was, a little 12 or 13 years old at the time. And I remember that stuff. I was very involved and very active in current affairs. I remember when all that happened. And I went through most of my life assuming that if nothing else, justice would eventually prevail and the Supreme Court would be on our side, and rights, even though they may not expand in a straight line, to paraphrase the old quote, the arc of history tended to bend toward justice. I'll be 70 years old in 2 years. And I will tell you that I no longer believe that the arc of justice or the arc of progress will always bends towards justice. I have been disabused of that notion. I will tell you why as we go on. First of all, I will begin this by stating something that I've always tell my clients whenever I have a new client and we're discussing a possible case, and that is that after more than 40 years as a lawyer in California, I can state, at least with certainty for myself, that in this country, you get as much justice as you can afford. If you have a lot of money, you will obtain a lot of justice. And if you have little money, you will obtain damn little. That's somewhat of a cynical view, but it is a view that I have come to after many years toiling in this particular vineyard. In all events, these are the issues that I want to discuss today. These are the constitutional areas that I want to bring up, because I think they will help us all to understand the very dynamic chessboard that we are all on, and how movements on that chessboard can affect each one of us. So what we're going to do is I'm going to start this by talking about the Second Amendment. Now, I will profess that I am not an expert in Second Amendment jurisprudence. I'm from South Texas, where everybody is armed to the teeth, but I don't own a gun. Although in my time in the Navy, I was a pretty good marksman. But nonetheless, I think that discussing briefly the background of the Second Amendment is an important factor when we are now looking at what did the founders of the Constitution mean, what was on, how was the Constitution seen by those who drafted it, and how does that view affect us today? Because those of you with any insight will understand that given the current composition of the Supreme Court, the notions that we read about in the media about originalism or intent of the founders. This is always something that comes out, and it's very, very important. And quite honestly, for many years, many of the theories that are now coming to the fore in terms of constitutional interpretation, frankly, were for decades consigned to the dustbin of history, the margins, the John Burt Society corners of society. I don't know about you all, but I remember in Texas when I was a kid, you'd drive out to West Texas and you'd see big billboards on the highway, impeach Earl Warren. And those billboards actually remained in Arizona through the 1990s, long after Warren was dead. But nonetheless, everything that is old is new again. In the 1930s, Franklin Roosevelt was president, and after his election in 1932, immediately began a whole legislative initiative to deal with the consequences of the Depression. And from those acts and from that era, we have many holdovers that form a bedrock portion of our lives today, Social Security among them. But the 30s under Roosevelt really saw the beginning of activist government. And for those of us who grew up in the 60s and 70s and 80s, we just assumed that our American experiment was a slow, often uneven, but a continual march toward some kind of progress. Unfortunately, I'm not sure that's actually so true. And I think that we are in a sense on a knife's edge. But as we look at this, I think it is important to look at some of the background and the history of the Second Amendment, precisely because, one, it is certainly an object of currency today. There are Second Amendment cases that come before the Supreme Court all the time. The issue of workplace violence, of guns on our streets. I mean, these are very, very important to each one of us. And but I think if you look back at the history of the Second Amendment and how and why it was adopted, many of the same arguments that you're hearing today about the right to bear arms and how extensive is it? Are there any limitations on it? These are all issues that, quite frankly, were front and center at the time when the Constitution was being debated and ratified. Just a bit of background. Remember, for the first few years of its life, this country was governed by the Articles of Confederation that we all learned about in 10th grade history. And the Articles of Confederation were basically an attempt by the then 13 colonies, who had just successfully waged a war against Great Britain, to organize their internal affairs. But there was a great deal of dispute at the time as to, because they had just come off of this war with Britain and the crown was seen as distant, arrogant, and unresponsive, the colonists were at great pains to assure that the new government that they were founding was not going to be characterized and possessed of the same defects that they found that the English crown was. That is, imperious, dictatorial, distant, and not accountable to the citizenry. So in the debate and the Sturm und Drang of all of the discussions in terms of how to improve the Articles of Confederation and how to construct the Constitution. The Second Amendment, or what became the Second Amendment, and specifically the right to bear arms, was a tremendously important and complex discussion. And I think it's important to actually look at that into some detail, because it actually, the same points that were made then are made now. And frankly, with some very, very good reasons behind them, whether you agree with them or not. In the first paragraph on this slide, we talk about whether the Second Amendment, for years, it was debated as to whether the Second Amendment, the right to bear arms, was an individual right or a collective right. Ultimately, the court a few years ago determined in a case called Heller that it was in fact an individual right. So then the question becomes, in modern jurisprudence, what are the limitations on the right to bear arms? And this gets back to the text of the document, that we had a militia back then. We didn't have, in the early days of the country, we did not have a military. We did not have police forces. And do not forget that the battles against Britain in the Revolutionary War were largely fought by people who were poor and penniless and who had nothing. So at the end of the war, the moneyed class, the elite of the colonies, realized that they, in a sense, had a tiger by the tail. They had armed an uneducated populace, largely farmers and people who were eking out a living. They had given them money and guns as much as was possible, and they had let them loose on the British. The war was successfully concluded, but suddenly the landed elites, the wealthy in the country, suddenly had a great cause for fear, because they had armed a population that could very well take up arms against them. So the question was, they had let this genie out of the bottle. How do they propose to put it back in? And the background in this country of the Second Amendment is inextricably linked to the background of the ability of individual Englishmen to carry weapons at a very febrile time in the history of the United Kingdom. In the 17th century, there was the revolution. The king was beheaded. All of these, lots of this complicated history. But as Faulkner said, past is prologue. It isn't really past. The past isn't dead. It is still with us. And many of the concerns that the English were debating in this era basically were ported over and formed the basis of much discussion the time the Constitution was adopted. And indeed, you hear echoes of this same debate around the right to bear arms today. So there was great concern that if you had armed weapons, if you had people with arms, they could destabilize the government, they could overthrow the king or whatever. But at the same time, in this country, you had the development of the colonies at a time when there was no military, there was no police force. Individuals had to basically resort to self-help in terms of law and order and violence. So, the yeasty debate over the right to bear arms was very, very important in terms of the formation of the Constitution, but also had real practical importance in terms of how people conducted themselves and lived their lives out on the frontier in that era. This is, again, a bit more English history, probably too much for you at this point, but there was great concern among the English about having armed men in and among the populace. And that was a debate that, again, continued after the Revolutionary War and as they debated the content of the new Constitution, which they were trying to get adopted in order to address the defects and the deficiencies and the problems that were evident when the country was governed under the Articles of Confederation. So, again, this whole issue of who is going to be armed and how these people are going to be regulated. This was a matter of great concern for the crown. It was a matter of great concern for the people who were drafting the Constitution. And I had to laugh as I was preparing this. I've read this before, and if you ever have a chance to read this paper by the Undersecretary William Knox, What is Fit to be Done with America? Some people might actually ask that of today, but that was certainly a question that was much on the mind in London, in the Brits in the 1770s and 1780s. And so there were all kinds of discussions about how do we prevent any future rebellion or an expansion of the rebellion in the American colonies. And these were some of the ideas that were quite discussed robustly at the highest levels of the British government. But ultimately, the revolution again is successful. And so now we have to develop our own system of government. And basically, what type of government were we going to have? A true direct democracy? Even back then, that was considered to be somewhat impractical. It might work for a canton in Switzerland to have everybody come around the pub on a particular evening and express their view about something and take a vote. But as a matter of a growing country, that kind of direct democracy didn't really work. So we had a Republican form of government. And then the question is, who gets to make the decisions? Where is power going to lie, and what are the limitations on power? So as we go through this process, the right to bear arms became very fundamental to the discussion about the relationship that the individual citizens were going to have with their new government, and about the relationship between the colonies or the nascent states and the to-be-developed federal government. One point of interest to note that George Washington was very, very, the war is over, and he goes back to Mount Vernon. He cedes power, doesn't really want power. But over the years, as the country floundered under the Articles of Confederation, Washington became very concerned that the new government, the new country, was going to be swallowed up by the imperial powers of France and Spain and England. We had won the war against England, but the English were still around the New World. The French were in the middle of the country, and the Spanish were in what is now Florida and portions south. So lots of imperial powers still ready and still eager to pick off what had been Britain's and was now trying to bring itself up to the fore in terms of its own nation. So as I said, the Articles of Confederation were proving inadequate to the job, mainly because there was no central power to tax. The government had incurred, the Continental Congress had incurred lots of debt from the war, but unfortunately the Articles of Confederation did not provide any tax base from which to raise money and therefore function. And one of the main purposes of a standing of a government back then was to have an army that could protect this new nation from the depredations of the French and the Spanish and anyone else, including the Brits, if they chose to come back. So the idea is that back in this era, you had militias, and that's of course became central to the Second Amendment. But there was a question as to whether or not the government was going to have a standing army, which many people opposed because they had just kicked the British out. The British had had a standing army in the colonies, and there were many who were vociferously opposed.
Wait, I'm sorry.
We lost your audio, Andrew.
How about that?
Yes. Yes, it's
Oh,
okay.
shit.
Yeah, I can hear you. Can you hear me? unmute yourself. You're muted now. You're still muted, Andrew. The red mute button is on. If you go to the bottom left side of your screen you can stop screen share and then turn yourself on again. I don't think I have I can ask you to unmute, but I can't unmute you.
He's turned it off. He's turned it back off. He's unmuted again. I don't know if he's hearing.
Andrew, can you hear us speak? Oh. So it shows that it's unmuted now, but we still can't hear you. How about your cord? Yeah. No. Try unplugging your headphone or plugging it back in. There you go.
Check my audio device.
Okay, we can hear you now.
All right. Okay, whatever I did. All right, Chris, that worked. All right. So the bottom line is, at the Constitutional Convention, you essentially had two groups of people about which you still hear today, the Federalists and the Anti-Federalists. I don't want to get into lots of detail about that, but these on the screen, you have a slide that basically depicts the two choices that were open to the delegates in terms of how they're going to deal with the need to have some kind of defense force, and yet at the same time ensure that they would not ever be subjected to the kind of force that the British Army had represented in the colonies prior to the war. So, I mean, and this is actually interesting for me now as a lawyer and somewhat of an amateur historian, because in the debate that you hear about gun rights and Second Amendment issues today, you will hear the echoes of these very same discussions and arguments and positions that were articulated more than 200 years ago. So the point is, this stuff, I mean, particularly for the Second Amendment and for the right to bear arms, this has been a subject of debate, and it has never really gone away. Only in the last 30 years has it kind of burbled back up, but the discussions and the lengths to which the government could go to limit the ability of people to have weapons has always been a huge issue in this country. And I really think that's the point I want to make here, because everything is so dynamic. When I was a kid, you know, the Warren Court was issuing all these opinions about civil rights and this and that. And again, we all developed, or at least I developed, this idea or this notion that the legal system would eventually find its way, and we would all have a sort of bite of the justice pie, as it were. I'm not sure I believe that anymore. And I think the next few years are going to be very, very interesting for all of us in terms of how these very old arguments are replayed essentially on a more modern stage. I don't want to get too, these are just, you know, some of the people of history that were basically directly addressing the issue of how much, how the issue of bearing arms and weapons was going to be addressed at that time. So you did have some kind of an agreement, and ultimately most people, because of just the way life worked back then, there were very few who were saying that you needed to disarm the populace. But the other side of that was everybody was saying you needed to arm the populace, because only an armed populace could prevent despotism. And that is an exact echo of what you hear today in many circles. So again, Past is not prologue.
Andrew, may
Yeah.
I ask you to go down to the bottom right and click on that screen icon again because we can,
Okay.
there we can read it better.
All
Thank
right.
you. very
Okay.
much.
All right. Sorry.
That's okay.
Okay. So ultimately, the way this debate was resolved at the time of the Constitution was that the Constitution was ratified, but as you can see from this slide, many states put conditions upon the ratification, and for a lot of the states, the condition was the issue of how are we going to allow people to keep their firearms? And again, this is not HIV in the law, but this is very much of a current topic. And just appreciate that the divisions in the country now on this topic are not new, and they were in existence over 200 years ago with the same kinds of debates and the same kind of arguments that we're hearing now. So anyway, again, I'm trying to illustrate here the complicated nature of this, the fact that it is there's a long historical debate, and the issue of how extensive now the Second Amendment is has no easy answer, precisely because it was such an important issue at the very beginning of the country. And even though our lives are very different, what with modern military and modern police departments, we're not living out on the frontier, basically relying on our own abilities with a firearm to keep ourselves alive and et cetera. But context is everything. But back then, this issue was of enormous importance. And it has not dimmed in importance at all as we've gone through the next many decades. The second issue that I want to discuss tonight is that of abortion. And this is getting kind of closer to, it's bringing us closer to concerns that we all have, certainly as people living in 2022, but certainly as gay people. And so again, HIV in the law always has with it the subtext of Con Law 101, because the rights that we enjoy today are basically built on the activities and efforts of a lot of other people over many, many years. And those rights are fragile and subject to possible rescission. I hate to say that, and 15 years ago, I wouldn't have said that, but I say it now. If you look at the history of abortion in this country, in colonial America, abortion was, sometimes it was proscribed by law, often it was not. And there was deemed no particular medical problem or societal or legal problem with aborting a fetus prior to quickening. Quickening was the ability of the woman to feel the fetus in her belly. And if you had an abortion prior to quickening, nobody thought anything of it. It was only after quickening that it raised issues. And of course, back then, the medical knowledge about what quickening was pretty rudimentary. But in all events, in 1865, Connecticut, of all places, passed a law preventing or making illegal contraception. And that becomes extremely important. It's a little historical footnote, but that state and that place become very, very important to us later on. Prior to Roe in 1972, this really was the state of play in the United States. Abortion was legal upon request in New York, in Washington State, in Alaska, and in Hawaii. Interestingly enough, it was just outright illegal in 30 states. And in the other states, it was proscribed but there were exceptions if the life and health of the mother or the fetus were in the balance. So it was kind of all over the map. You had a wide divergence of practice prior to January 1973. In 1973, in January, the Supreme Court issued its famous Roe versus Wade case. And the reason I'm focusing on that, Roe versus Wade has many legal principles that underpin it. But one of the most important for us is the idea of the right to privacy. Now, the right to privacy was famously referred to as a penumbral right, a word that only an astronomer would know. And it has its origins in a 1965 case, Griswold versus Connecticut, where a married couple sued the state of Connecticut because they had been prosecuted, or the wife had been prosecuted for obtaining a birth control pill. Birth control pills, remember, came out in 1962. So, began to change the landscape, the societal landscape in a lot of different ways. So the court first recognized in 1965 that individuals had a right to marital privacy, at least married couples did, in terms of whether they would use contraception or not. And even though there is no right to privacy in the Constitution, we know that there is a right to bear arms because that sits right up there in the Second Amendment. But the right to privacy appears nowhere in language or text or in dicta in the document, but it was inferred basically that all Americans have certain privacy rights that are so intimate that the government should not be able to interfere with your exercise of those rights. Initially, that right was deemed, was extended to the provision of contraception for married couples. A couple of years later, in another case called Eisenstadt, the right to contraception was extended to people who were not married. And eventually, the right to privacy in 1973 is expanded by Roe. But again, I want to emphasize the right to privacy is central to Roe, but there are other pillars of constitutional doctrine, equal protection and the right to due process. These are very, very different constitutional concepts, but they all came into play with Roe. But as you go forward from Roe, the right to privacy is expanded on in two areas that are of enormous importance to you and me. And that is that the right to privacy was the grounds on which the Supreme Court struck down the Texas sodomy statute in Lawrence versus Texas in 2003. You remember the Hardwick case, Hardwick v. Bowers in 1986, where a man was arrested in his bedroom in Atlanta. Two guys were having sex. And in that case, the Supreme Court upheld, in 1987, the Supreme Court upheld the right of the state of Georgia to proscribe sodomy. Several years later, in 2003, the state of Texas, attempting to do the same thing, found its law struck down as unconstitutional because, again, it violated this right to privacy. And it is the right to privacy that forms one of the foundational principles for the Obergefell case in 2015, which gave us all the right to marry. Each of these cases, I want to emphasize, encompasses more than just the right to privacy. But if the Supreme Court finds that there really is no right to privacy, then this foundational pillar to all of these cases that impact each one of our lives so profoundly is suddenly pulled out from underneath. I don't know how the Supreme Court plans to do this, But my suspicion is that certainly the 5 conservative justices on the current Supreme Court, put there by the decades-long effort of many people through the Federalist Society, they have an agenda. And my goal here this evening is to kind of explicate, in my view, that agenda is not only the expansion of Second Amendment rights, but it is the diminution of the rights of gay people. Whether ultimately the right to same-sex marriage will be tossed out, I don't know. But I find it very interesting that only 7 years after the right to marry was deemed a constitutional right, there are those who are now licking their chops over the idea that the Supreme Court will begin now to limit the scope of the right to marry. Whether that will be successful and how that will be done, I do not know. But I know the effort is there and the effort is going to be made. One of the things that I think is really the goal of the Federalist Society and of the cadre of conservative justices on the Supreme Court, it's more than just same-sex marriage. I think that's certainly in their sights. But in my view, it is the entire, the real goal here is the dismantling of the regulatory state. And I mean that quite seriously. We have all grown up in a United States where the power of the federal government is very pervasive, and we expect it to be so. If there's a natural disaster, we expect something to happen, somebody to step in, some agency or group of agencies to step in if there's a natural disaster or anything. And the fact of the matter is that Congress, over many decades, has developed a body of law where it basically says, because the Constitution gives us the right, gives Congress the right to legislate for the general welfare, that many of the things that we do are done pursuant to the overarching goal of Congress and the ability under the Constitution to legislate, as I said, for the general welfare. And the question is, what does that mean? We've always assumed that that meant, for example, that the federal government could regulate interstate commerce and could prevent somebody owning a motel on a side road in outside of Montgomery, Alabama. You could prevent that person from refusing to rent a room to a non-white individual. And the way that was done, the constitutional pathway to that kind of regulation was through, just by way of specific example, the Commerce Clause. The Constitution broadly gives Congress the power to regulate commerce among the states. And it was through the vector of the Commerce Clause that many of the civil rights acts were passed by Congress and imposed on the states. And for many decades, people just thought, all right, well, that's quite right. The Congress has the ability to do that. Well, does it? You now have a conservative Supreme Court majority that is going to begin to question many of the actions of Congress and the executive. And it is my view, it is my fear that the voices that were for many decades on the edge, the John Birch Society, the people in the far shadows, those voices have now come front and center. So the question is, and just, I don't know if it's on this next slide, last week or 2 weeks ago, the Supreme Court, through its 2 cases involving Biden's COVID-19 mandates, vaccine mandates, and the court upheld one and struck one down. The one that they struck down was a mandate that that OSHA had promulgated, that any employer with more than 100 employees had to require that their employees get vaccinated against COVID-19. The other group of cases involved healthcare workers who were required by OSHA also to be vaccinated. And the Supreme Court basically dealt a kneecap blow to the Biden administration's plan with respect to COVID by saying you cannot have an employer mandate. So you can look at that and you can say, well, that's interesting, perhaps unfortunate, depending on your view. I think it is. But do understand that this case is the nose of the camel under the tent flap. What the Federalist Society, what the conservatives are trying to do is basically bit by bit get this Supreme Court to chip away at the ability of Congress to deal with everyday problems. For example, climate change. There is no question that climate change is real, that it is bearing down on us, that the effects of it are coming much sooner than anybody anticipated. I mean, I've been doing climate change work in Europe for over 20 years. And the assumption you'd go to these big international meetings would be, the assumption was that, oh, by 2050, we got to get our shit together or something's going to happen. And now we're realizing in 2022 that, there's an article in today's Guardian, 2014 apparently was a irreversible tipping point for the oceans. We've already passed it. And who knows what will lie ahead in the not very distant future. The point is, this legal theory that says that Congress is unable to do anything unless the Constitution explicitly articulates the right to do that. If you follow that legal theory to its conclusion, basically there is damn little in the modern world that Congress is going to be able to effectively accomplish. COVID was certainly not around. Public health was not around, certainly the way it is now at time the Constitution was being drafted. So this fealty to original intent, to the true text of the Constitution, while it may be admirable, basically it's the other side of the coin. Whose ox is being gored, as my mother used to always say. And will the court continue to grant Congress the ability to respond to circumstances as they develop over time? COVID is just an example. It is an exigency that has arisen, and there has been a legislative and a public health massive response to it. But what happens when you have the Supreme Court, unelected, say, wait a minute, you can't do that? There were always conservative voices on the Supreme Court. Even back in the 30s, there were Supreme Court justices who thought that, and who would have been willing to throw out the whole Social Security system as being unconstitutional, a massive expansion of federal power at the expense of the states. And there have always been people on the right wing who have held that view that even Social Security is actually unconstitutional. Now, for decades, nobody listened to those little voices talking in such terms. But those voices are now moving toward the center as you have more and more of the Federalist Society. I mean, I'm an old fart. I graduated from law school almost 42 years ago. And when I finished law school, the Federalist Society didn't even exist. Now, nobody gets a job in the federal courts as a court clerk. You don't get a job as an aide to a Republican senator or congressman. If you're a lawyer, there's only one pathway to those positions now, and it is through the Federalist Society. So don't mean to spend a whole lot of time on that one group, but the point is that we are really at a very, very critical point in the development and in the evolution of our constitutional structure. Because when you have a threat and a crisis such as COVID, and you have the inability of the executive to respond accordingly, i.e. this case in the Supreme Court where they said Biden had gone too far. The Congress does not have the authority, or the administration does not have the authority, even in the midst of a public health crisis, to respond as it did. You're on a very, in my view, a very, very dangerous slope. Because if you're going to go back to the idea that the Constitution means what it says, the words in the Constitution are in black and white, and if it's not in the Constitution, it doesn't exist. So there's nothing about gay rights in the Constitution. There's nothing about women's rights. There's nothing about civil rights. Well, certainly there is in terms of the later adopted civil rights amendments, the 13th, 14th, and 15th Amendments. But the point is, if you get a court to a place that basically says, unless it's in the Constitution, you can't do it, then how do we function in the modern world with all the crises and the issues, whether it's conflicts with Russia over Ukraine, whether it's the development of pathogens that require a robust public health response, whether it's the right of a woman to choose whether to terminate a pregnancy, or whether it's the right of somebody like myself to get married to my husband. The point is that I really do fear that these debates and issues that are so vividly illustrated by the disputes taking place 230 years ago regarding the right to bear arms, many of those discussions are still ongoing. They are still potent. They are still valid. And when I was a kid, the assumption was, well, you can always seek redress and seek justice in the courts. And if you can't get anything through the legislature, the courts will save you because they are the last best hope for all of us who don't have a lot of political power. And the assumption was that in the end, that the courts it may take them a while, because courts never lead in society. They always follow. And the idea was that the courts would eventually do the right thing. I'm not so sure that's true. And I am deeply disturbed when I read a decision, and I have read the Independent Business versus Department of Labor case. Basically, they're basically saying that the executive does not have this power because the Constitution doesn't give him this power, and Congress has not explicitly granted this power. And in the absence of that, there is no power to act. So now in this particular case, if the federal government doesn't have the power to mandate that employers require vaccines for their employees, there's nothing to say that employers cannot still do that. But that's a volitional decision made by private business and private enterprise. So, this really is crunch time for all of us. We've talked in the past in these lectures about the status of criminalization of people who had HIV and the reasons for that, and how with developments over the last 20 years, lots of those laws have basically become null and void. In some places they have been repealed. But in other cases where much of our day-to-day life is predicated on the assumption that we have a right to privacy, when much of our day-to-day decision-making is predicated on the fact that, well, of course we can do that because we have the Civil Rights Act, or we have, this mode of redress. All of these things that I have taken so much for granted in the last 40 years, and I think probably many of you as well, I think a lot of these things are really under threat. And of all the cases that are ongoing, and all the Sturm und Drang about the Supreme Court, the one that just really bothered me the most was this case recently where they said that the president could not enact a vaccine mandate, because I think that is the writing on the wall for what this court majority wants to do. What the right wing cannot do politically, they may be able to do judicially. You know, when I was a kid, through much of my young life, the Republicans would rail and go on about activist judges. And suddenly the shoe is on the other foot. And I find it very interesting that this current cadre of Supreme Court justices almost thinks that, I don't know how many people over the course of our history have served on the US Supreme Court. It is a small but finite number. But I find it unusual and troubling that it is only this cohort of Supreme Court justices who have said, or who are basically in the process of saying, you know, all of our colleagues in the past had it wrong. We're the ones who have received wisdom, because we know, unlike all of our fellow justices over the many, many decades and centuries, that we are being true to the Constitution and they somehow strayed away from it. And I think that's sort of where we are. That is certainly my fear about where we are going. And I think the implications for each one of us, I would say in this room, but for each of us, those implications are quite profound. This is just some of the language, particularly this third paragraph, where the dissent in that case pointed out that the court is substituting its judgment for that of the experts, which in a sense is basically what the court is getting ready to do in a whole lot of areas. I mean, it is so ironic to me that a group of people who have bitched and moaned for decades about unelected judges, they're not saying that anymore, simply because the judges that they now have put in place are basically very likely to do their bidding. So anyway, that's who we're up against now. We may have another Supreme Court justice very soon. This is actually a headline from today's Associated Press. Justice Gorsuch is making a speech to the Federalist Society to which the media will not be admitted. And I think that basically speaks to the kind of ethical makeup of the current Supreme Court, and the fact that that the justices feel free to engage in this kind of public relations display. 40 years ago, 30 years ago, this would not have happened. Anyway, so we have a new person in the White House, and today this is a photograph of the president, the vice president. Supposedly they're discussing their pick for the Supreme Court. I find it interesting when Biden says that, quote, the Constitution is always evolving slightly on rights. That is certainly his view. That's my view. I am not sure that that is the view of Justice Alito, Scalia, who is now dead, Thomas, Gorsuch, Barrett. I'm not sure that's their view. And I think we're in for a really, really bumpy ride. I don't know where this is going to lead. I ultimately think that many of us are going to be shocked by some of the decisions that come out of the Supreme Court over the next few years. And I think the impetus for the expansion of the Supreme Court is going to grow. Whether that will be successful, I have no idea. But in all events, I've been talking for over an hour. Are there any questions? And I hope you have learned something.
Yeah, hi, Andrew.
Hi, Andy.
Hey, I agree with you on your view of how things are going. It's very disheartening. History question was the Griswold v. Connecticut case against the contraception law that passed in 1865, so 100 years prior?
It was, yes. I don't know why. I've not really looked it up. I don't know why contraception was deemed such an urgent issue in Connecticut in
Right.
1865, one would have thought with the Civil War winding down that the legislature would have had better things to do. But nonetheless, yes, that was the law. And the reason is, remember, the pill came out in 1962. It took some time for big pharma to begin to popularize this, but by 1965, it was inevitable. There were many states that had laws against contraception, not just Connecticut.
Okay.
But it was inevitable that would eventually, given the pharmacological developments of the early 1960s, it was inevitable that eventually a case like this would come to the fore. But it's really that the important is not so much the contraception background. It's that this case recognized that whether the Constitution said it or not, all Americans possessed this
The right to privacy.
the right to privacy.
Right.
And I mean, I think that's a really important thing. We assume as Americans, as citizens, we talk about how we, there's always been this country in a sense has always been at war with itself, with its better nature. The Declaration of Independence was a breathtaking, truly groundbreaking piece of writing. And when it was promulgated and published, it flew around the world. It inspired people all over the world. But 13 years after the Declaration of Independence, which basically said all men are created equal, we are all equal before God, we are entitled to all of these things, it all sounds good. 13 years later, after the war has won, once the white gentry, landowning, wealthy white men realized that they had a tiger by the tail, they had an armed populace who had just fought a war and were not easily going to go back on the farm and to be ground back into the dirt. The people who were fighting the Revolutionary War, by and large, were not white landowners. They were the tenant farmers and the people who had nothing. So 13 years after this most articulate, exquisite declaration of universal human rights, 13 years later, they're forging this document that basically excluded anybody that wasn't white, that wasn't male, and that didn't own property.
Right.
So the much vaunted high-blown articulations stated in the Declaration of Independence were pretty much cut off at the knees within 15 years. But nonetheless, we all have this idea that we have certain things as Americans, and the right to privacy, which is so personal to each of us. The idea
that's why I find this perspective, the prospect of them overturning Roe v. Wade based on privacy, I find it not only appalling, but how are they going to come to that? Because the right to privacy is now so embedded in these other decisions for us.
Well, I think that illustrates the old bromide. You better be careful about what you want, because you just might get it. Because Andy, you really raise the point. Gay marriage. I mean, people think that the issue of gay marriage kind of came up out of nowhere. No, it didn't. The first federal case over gay marriage was filed in 1970 when a brave couple in Minnesota went into the Hennepin County Courthouse to get a marriage license, and they literally were laughed out of the building.
Right.
They went to court and they were laughed out of court. That was in 1970.
Right.
And so the decades-long fight for same-sex marriage did reach its culmination in 2015, but now it is widely accepted. People who are pushing for the rights for trans and non-binary people. Buckle your seatbelts, folks, because it ain't going to happen overnight. Nothing does. And nothing that does happen is secure. And back to your point, Andy, I don't know how they're going to deal with same-sex marriage when it is vastly now supported by about 65% of the American people across the board.
Well, by the same token, abortion rights are supported around in 60 to 65%, as I understand it.
Well, it's going to be very interesting. One of the things that the Republican Party does, in my personal view, they always overreach.
Hmm.
So we are all waiting with bated breath for the decision from the Supreme Court regarding the Mississippi abortion law.
Right.
I can guarantee it that right now on some legislator's desk, whether it's in Texas or Louisiana or Mississippi or South Carolina, there will be an effort to limit the ability of women to get contraception.
Oh.
This is like the vampire that was not dispatched with a silver stake through its heart. This issue will rise again, like the people in the South want the South to do. And I don't know how they're going to deal with this because the world has changed. You can talk about wanting to take the Constitution back to the 1780s when all power was in the hands of white landowning men. And there are some people in society who would love to go back to that era, I am sure. But the plain fact of the matter is that that ship has sailed. So how this is going to, as a practical matter, how it's going to play out, I do not know. But I think the first step is not going to be a frontal assault against same-sex marriage. The first way you're going to see this come to the fore after the Mississippi abortion case is that sure as shooting, there will be attempts to limit contraception, largely
So,
because.
Andrew, I'm sorry. I thought you were taking a break. So how does that Texas law about turning other people in, the abortion law, that it isn't the government who's enforcing a law, it's citizens out on the street. Like where I see that going for us is like, we're going to be turned in for giving someone a blowjob or something. So like, where does this stop? I mean, I thought the Texas one was more pernicious than the Mississippi abortion
Texas
law.
I mean, it's very, because Mississippi is a frontal, a direct assault against Roe versus Wade. I mean, the bottom line is Roe actually, and Blackmun wrote the decision. If you read it, because I've read it many times. Roe is actually a brilliant articulation. Forget the law. He looks at the advances in medical technology. And basically that's where you come up with a trimester system. On the, in 1992, there was this case called Casey versus Planned Parenthood. And in that case, Sandra Day O'Connor, then as Associate Justice on the Supreme Court, said Roe is on a collision course with itself. And what she was referring to was that in her view, and this is 30 years ago, that science would push back the point of viability. Because in Roe, the concept is in the first third of pregnancy, a fetus is not viable. And so the decision as to whether to terminate or retain is the woman's herself entirely, hers and her doctor's. As the fetus gets older and develops, the interest of the state becomes greater until in the last semester where a fetus would truly be viable outside the womb, the interest of the state in regulating that abortion is greater than the interest of the state in regulating that abortion earlier on in the pregnancy. Mississippi's case is a direct challenge to that, basically saying, as soon as you can feel a heartbeat, that's it. Now, that's a heartbeat is perceptible through examination. It is not perceptible to the woman for weeks after that. But the point Chris makes is it is the enforcement mechanism in the Texas law. Texas doesn't, well, it does directly attack the timeline of Roe, but it's the enforcement mechanism. And Chris, my only point to this is, again, you better be careful about what you want because you just may get it. If the Supreme Court gives its blessing to the state of Texas for allowing third parties to sue and therefore enforce a law that the state writes but does not act on, then sure as shooting, somebody else in some other state is going to, you will see laws in California. You will see somebody introduce a bill somewhere along the lines of where automatic weapons are prohibited, but the state will not be the vector by which that prohibition will be enacted. It will be private citizens. In other words, sauce for the goose, sauce for the gander. Because Chris makes the point, rightly so, that that's why, I mean, you never underestimate the ability of the conservative mind to take the whole cake when a bite will do. This enforcement mechanism in Texas is, I mean, the Supreme Court, to its everlasting shame, in my view, has allowed the law. They've basically said, we're not going to discuss the enforcement mechanism until we have an actual case arise. In other words, until somebody attempts to sue in Texas. So, I mean, you know, guys, we are in a whole new ballpark. The kind of legal theory that gave rise to the Texas law, Chris, 2 years ago, I wouldn't have thought of that. Very few people would have. But when you give people enough rope to hang themselves, they invariably will do a very good job at it. And I think that eventually, I don't think the Texas law will stand, because I think that they will realize that, again, if it can be applied in one context, which the right wing likes, then it can certainly be applied in another context, which the right wing would not like at all. And if you're going to go down that path, then really all bets are off. You know, when you're in law school, you'll in first year criminal law, you learn about rough justice and self-help. If you were living on the Kansas plain in 1870 and somebody did you wrong, you would go get your own kind of justice. And eventually society moved away from that, and the idea of collective justice, that collective justice was going to be more just and less dangerous if the state moved in to enforce criminal law, et cetera. But if we're going to go back to the frontier, where it's basically every person for themselves, I don't know how that works. And again, it gets back to the old thing. You better be careful what you ask for. You just might get it, because who knows where that path will lead. And I mean, even conservative jurists, I think, realize that the Texas law is the real, it's the lid on Pandora's box. And I don't think they want to go there, but who knows? I mean, you read any one of these dissents from Justice Thomas, as far as he goes, you know, the Constitution said nothing about airplanes. That ergo we can say nothing. We can say nothing about planes. I mean, that's really where it gets down to.
His wife is writing his dissents.
Well, how that's allowed.
So
yeah,
we've come to the end of our time.
Okay.
I'm sorry to say, I wanted to check with the other guys if anyone else had any questions. Andrew always has some great questions, Andy, but I just want to make sure that if there were any other questions from anyone, that we got a chance to get these out. And if not, we thank you for joining us tonight. And it's we will be following these things closely as they unfold. Some of the stuff won't be happening until next October with the new session, but
well, we will all wait. In June, this raft of Supreme Court decisions will begin to be announced. So we will await that with bated breath. But thank you all. It's I hope that you didn't mind my diversion from HIV and the law to sort of con law 101. But I think it's really important to understand context and the broader scheme of things, I think. And we're just in a very yeasty portentous period.
Is there a HIV case coming up before the Supreme Court? I thought there was one that was involving it but I might be mistaken, that I might have been dreaming.
Christopher, I am not aware of it.
Okay, then
I am not aware of it.
I'm not aware of any either. I do know, I know that some states have started to repeal the HIV, prohibition laws. I think New Jersey did.
Several states have. I mean,
Yeah.
lots of laws were adopted in the late 80s,
Right.
as a result of the fear, but
And
a lot of those are going by the boards.
I thought it was the Louisiana law that was
oh,
coming up.
okay.
It could be.
And I know New Jersey passed a pro same-sex marriage law to put same-sex marriage into being legal in the state of New Jersey, and that's a bulwark against the possibility of Obergefell being overturned in the future.
Yeah.
Yep.
And more states need to do things like that.
All right, guys.
And same thing with the abortion laws.
Well, I think this generation of young women who have no idea. I mean, I remember when I was a kid, I had friends who were older than I by a few years, and there was an underground railroad, and they would take young women from Texas out to California.
Yeah.
And I knew a couple of the drivers. I was too young to do it, but the world, the world of the Federalist Society can't wait till we all go back to an era where all the decisions were made by straight white men in closed rooms where they didn't have to deal with anybody else.
Yeah.
And for many people, they would just as soon go back to that kind of environment. But we live in a different world. And I do fear what's coming down the pike, but I also know that we live in a very, very different world. And many of these decisions will prove to be extremely unpopular. The question is whether or not democracy will have been so subverted that any decision can be addressed by democratic means. We shall see. Gentlemen, again, it was a pleasure being with you. I hope you all learned something. Thanks very much, and we'll see you next time.
Thanks, Andrew. Yeah, say hi to Buddy for us.
I sure will.
All
Bye,
right.
y'all.
Right.